Hello, lovely people. Another Saturday afternoon is here with us, and we're live on the community and the law. We're bringing you a very interesting discussion this afternoon. My guest, lawyer Charles Asma, will be doing justice to that. The question is, how do you go about in a different way to meet the financial requirements for a UK visa? We'll be delving into that. If you have questions, get them ready. If you want to contribute, join us live on Facebook and YouTube at BWF Solicitors and at BWTV UK. It's the community and the law.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Another Saturday afternoon here with you, and we live on BWTV, bringing you the community and the law. My name is Oriku Frimpong. Welcome. Today, I am going to help us look at a very interesting topic. We're going to look at several other ways of meeting the financial requirements for a UK visa. We're doing this courtesy BWF solicitors, our trusted friends when it comes to the law. And from their stables, our resource person will be lawyer Charles Asma, who will help us look at the various options. Now, when we talk about meeting the financial requirements, we will be looking at the amount of money that you need to have at least in your account or to show for your visa to be considered. We call it a threshold. And what is the law saying, and what are people also doing about it when it is that you are not able to meet it straight away? Maybe that's the way I need to put it. So we will be having that. So if you have any questions on that or any other question regarding the law, especially with your immigration matters, please come join us and get your questions ready. We're live on Facebook at BWF Solicitors and at BWTV. We're also live on YouTube at BWF Solicitors and at BWTV. My name is Oriku Frimpong, as I mentioned earlier on. I'm doing this courtesy BWF Solicitors. People have experienced the services of BWF Solicitors, and they always give us the feedback that we need to encourage us to do what it is that we do. So if you have experienced the service of BWF Solicitors, you have any feedback to give us, just go over to social media handles at BWF Solicitors or go on Google and give us a review. Now, I have Sami B, who has done exactly what I'm asking you to do. And Sami says that exceptional service with genuine care. Sami goes on to say that he cannot thank BWF Solicitors enough for the support and guidance they provided him during what was a very difficult time for him. From the very first meeting he had with BWF Solicitors, he felt understood and truly cared for. BWF Solicitors, according to Sami, handled his case very well with utmost professionalism, expertise, and attention to detail. But what really touched his heart was their kindness and patience. Sami goes on to explain and tell us that BWF Solicitors explained everything clearly, never made him feel rushed, and also responded promptly to his calls and emails. They didn't just trust me as another client, they treated me like family, he says. Knowing that I had someone as reliable and compassionate on my side, this gave me immense peace of mind. So Sami continues to say that I would absolutely recommend their services to anyone looking for legal help. Thank you for going above and beyond and for making a successful and a stressful progress feel manageable and successful, I should say. You are truly amazing at what you do. God bless you, Uncle Ben, Helena, Asma, and the whole team. Well, that's very deep and funding and deep and heart touching, I should say. And yes, that's exactly what you get when you come to BWF Solicitors. So I recommend that you make your way to BWF Solicitors when you have an immigration issue or any legal issue, and call them on 0208 493 7340. I say the number again. You'll find it at the bottom of your screen pretty soon. 0208 493 7340. Those of you in Ghana, there is an office, BWF is open, and through that as well. You can call them on 055 589 5959. 055 589 5959. And in emergency situations, whatever there is that you need to get to, let BWF Solicitors know. text, WhatsApp, or call 077 127 61884. 077 127 61884. BWF Solicitors, trusted partners when it comes to the law. And they give us the opportunity to educate ourselves and empower ourselves when it comes to handling our legal matters. And that's why they give us programs on Thursday morning, Friday mornings, and then on BWTV Saturday afternoon. And the program is the community and the law. And we're going to get into that because definitely you need to have that empowerment. And again, they also give us the opportunity to learn things, put them in our pocket, run along with that, and get us to have that absolute understanding of what the law says. And any updates that come up, they do not hide them from us. Now, the nuggets we have for this week is about skilled worker visa and side income. Will it affect your indefinite leave to remain? A very good question. Now, let's see. If you entered the UK on a skilled worker visa, for example, in 2022, and you earned additional income from content creation, brand deals, or freelance activity, this does not automatically affect your indefinite leave to remain, but compliance is critical. Side income, including influencer or digital earnings. Those of you who do a lot of things on social media, Facebook, TikTok, and all the other bits. And you help people promote their products and services on social media. We use it as an example. So we say side income, that is including what I've described, is permissible. But non-compliant work, especially exceeding 20 hours or falling outside permitted roles, can jeopardize your indefinite leave to remain. It's a bit technical, it's a bit not straightforward. There may be some questions you have around this. So stay tuned, and we will be coming your way with some explanation when Lawyer Charles Asma starts his presentation, and also whenever he does his introduction and says his good afternoons to all of you. So yeah, get yourself ready. As I said, we are live on Facebook at BWF Solicitors and at BWTV, and on YouTube at BWF Solicitors and BWTV. So if you're a skilled worker and you have a side income, the question you are asking would be answered pretty shortly. And then later on, I'll give you a scenario to test your knowledge of what it is that I have put across and see whether you can get a good answer. Now, whatever it is, even if you get it wrong, we would have Lawyer Charles Asma around who will help us get the correct answer. Now, the scenario I'll be giving you is what we have find on our screen at the moment. So Baba Samu, a third-party supporter, provided a letter for the Home Office explaining the size and number of people living in his home and that he could no longer support Co-Brown. Baba said that he was not prepared to disclose his personal finances to the Home Office as this was private information. Co's request for fee waiver was rejected and he contemplated judicial review. What is the likely outcome of this one if he does? As Baba did not disclose his financial condition, this affected his application, or affected Co's application, so to speak. Baba is a good Samaritan, so he cannot be asked to provide his personal information. Then the third one is, as this is Co's fee waiver, he does not have to provide Baba's information. So look at the scenario pretty well. Baba Samo is a third-party supporter, so he is supporting somebody's application, okay? Then provided a letter for the Home Office explaining the size and number of people living in his home and that he could no longer support Co-Brown. So Co-Brown is the main person who is putting in the application. Baba said that he was not prepared to disclose his personal finances to the Home Office as this was private information. Co's request for fee waiver was rejected and he contemplated judicial review. So then I gave you the three scenarios. One, you would choose to give me whether you think that's the correct answer. as Baba did not disclose his financial condition, this affected his application or affected Cole's application. Baba is a good Samaritan, so he cannot be asked to provide his personal information. And third, as this is Cole's fee waiver, Cole being the main applicant, he does not have to provide Baba's information, who is the third party supporter. Think about that. We will come back to this. And you know what? We need to be grateful to BWS Solicitors. So at this moment in time, I'm inviting you to join me as we get their message, pick up their number, and also get in touch. BWF Solicitors are trusted partners when it comes to the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back from the break, and thank you for sticking around. I know you would have made yourself available and mentioned yourself in the comment section below, either on Facebook or YouTube. If you haven't done that, let's take a moment to do that as I am doing mine now. Go on your phones, get on your laptops, get on your iPad, click on the link and share. And those of you who are new here, click on the like button and the subscription as well, so that when it is that we put content on, you will be notified. Sorry. Adesafo comes up and says, please share when you join. Thank you very much, Ade. Thank you for your support and contribution all the time. I know others are coming up, so when it is that you get in here, drop us a comment so we know you are on board. Ladies and gentlemen, I mentioned earlier on that we're doing this courtesy BWF Solicitors, and we have our brother, learned friend, so to speak, and a lawyer from the stables of BWF Solicitors, lawyer Charles Asma. Uncle Charles, good afternoon.
Good afternoon, Brakoku.
How are you doing?
By God's grace, it's
Yeah.
a beautiful afternoon, and we are grateful to God.
Yeah, the sun is so brightly out and it's a bit hot. With us human, interestingly, we always complain about everything. When it's hot, we are complaining. When it's too cold, we are complaining. But God knows all
In
the
in,
best.
in economics, in economics,
Mhm.
there's something called insatiability or
Uh-huh.
satiability, and we learned that human beings have insatiable wants. Whatever you give us, we want more.
Well, whatever it is, we will complain. But we're not complaining about the fact that you are here with us because we are very grateful. Um, I would reiterate that Sami B has said that he attended BWF Solicitors, had some good service provided, and he's so grateful. And he says that he would not hesitate to recommend BWF Solicitors to anybody who needs professional support when it comes to the law. He's talking about certain qualities: kindness, treating him as a member of a family, making sure that he was heard, and also getting him through a very disturbing situation to give him some solution. Uncle Charles, we're grateful. Thank you very much.
Sure, right. So this is what we do. BWF Solicitors is a community. We
Mhm.
deliver solution. Regardless of the problem, we'll find a way to give you a testimony. And this is what we give our friend.
Well, thank you very much. But then, as Oliver, we will still ask for more. You helped us with the nugget earlier in the week, and we want some further explanation on that. In this era, there are a lot of skilled worker people here in the UK who are always having questions and concerns about their situations here and there. Some have been giving notice to leave the country or do something. Other than that, the business may be curtailed and all the rest of it. Now, people are also worried about the fact that you are in here to do a particular job, but they may have some other skills that would help them earn extra income. Do they necessarily have to declare that and all? Skilled worker visa and side income. Is it going to affect people's indefinite leave to remain? That's what you're giving us. Would you help us with some further explanation as to what this one means?
Right. So we know that people are on skilled work visas and they have specific conditions to meet. One of the conditions is that you have to be working with the main employer. And within the same industry, you can be working extra of 20 hours. So if you are a skilled worker carer, you can work for the main employer, ticking the boxes for the main employer, and working in the same industry for another employer as a carer, 20 hours top up. That 20 hour does not replace the main job. What it
Mhm.
means is that if you are doing 20 hours, it doesn't take over the main job for for indefinite leave to remain purposes. Now let's look at other people who are doing side gigs like content creation and so on and so forth. I mean, if you are a content creator, somebody called me about a month ago to say, lawyer, I'm an influencer, I earn X amount, blah, blah, blah. What do I do in terms of tax? So I said, call HMRC and explain to them. He called HMRC and go back to me to say, oh, they said if I'm earning up to $1,000, I don't have to worry. So I said, well, what you are earning is just about $1,000. That means you don't have to worry. He had his peace of mind to know that he's okay. And that is what anybody who is doing things like this must do. As long as you are working for the employer on the main skilled work sponsorship job, you are okay. If you are doing 20 hours on the side within the same industry, you are okay. However, content creation will not be the same industry. And the question is, will you be classed as self employed or not? That you deal with HMRC. but that will not again affect your main job for which you've been sponsored if you are keeping to that job's condition.
Okay. So then, if, for instance, I work as a content creator, for instance, and it's not my main job, I earn more than 1,000, or let's even say £1,000, in addition to the minimum that is being paid by my main employer. Is the HMRC probably going to add that my side income to my main one and tax me on that? Or once it doesn't meet that threshold, I am okay?
I earlier said that somebody called me with similar question, and I told the person to speak to HMRC and give me feedback. The person got back to me to say that HMRC said that if they earn X amount, then that's fine. We are not saying that people should stick to that response. And so if you are a content creator and you are not sure for tax purposes how you should account for that, call HMRC and tell them that you are a content creator, you are earning extra income on the side for what you do because you are using your talent and your hobby and whatever it is, you are converting it into um, income. And so, what do I do? They will tell you what to do. Then you have complied as far as taxation is concerned for that extra income. However, that does not take over your main reason for being in the UK as a skilled worker. Your main reason is to work for that employer. So you still have to be working for that employer.
Okay.
And so if you're not working for that employer and you are ready for your indefinite, of course, then that will be difficult. But if you are earning on the side, will that affect your indefinite? As long as you are complying and HMRC has given you directions of what you need to do, you have complied. The key thing is compliance.
Okay. Well, folks, as Laura has said, the key thing is compliance. So if there are things that you need to declare and you don't, it may affect you one way or the other, especially when it comes to your indefinite leave to remain in the UK. Laura, the other question I'm asking in addition to this, if I have to make a declaration to the Home Office, but I refuse and say and give reasons of some personal information or personal reasons, so I am not going to declare my income, some information one way or the other. Would I stay within my rights to say, well, I have provided or have even said something under the definition, so the Home Office cannot quote unquote do anything to me? I'm asking that because I posed the question to my viewers as to somebody saying that I am not compelled to declare my income because I am a third party supporter. Do I necessarily have to provide every information that the Home Office requires and requests for?
In terms of is it on the same nugget or a different point you've raised?
I posed a scenario where somebody is making a fee waiver application. Somebody was supporting the person earlier on. The person is withdrawn, and now the Home Office is saying that the person should declare their income even though he has withdrawn his support. That's what I'm asking. That if they ask me to provide some information and I don't feel comfortable doing that, would they hold me to account?
Okay, I get what you mean. Right. So third parties are not obliged to do so. And you cannot punish the said third parties. You cannot punish the applicant who is making a fee waiver request for the decision of the third party not to offer. However, it depends on the context. It depends on the context. Because if you were to have the context to this, it would have probably and that would have helped our viewers as far as this particular question you have posed.
I think I have deliberately not given you the context because I'm asking them to answer the question, so we'll come back to you. So
Exactly.
if
Yeah,
you
so then
permit me, I'll hold on to the detail.
Yeah, in that case, we'll come back to that because remember, every scenario is based on a legal point.
Okay.
And so we cannot discuss an approach to handling that scenario without making reference to the legal point.
Okay.
And so, if we are going to discuss that, then I also propose that you bring that legal point that underpins that bit. And I'm sure producer will assist us with that as we go along, so that we bring that into perspective, so that our viewers who will also be supporting us to address that problem will have an appreciation of the basis of that response.
Okay, so this is what I put out. That Baba Samo, a third-party supporter, provided a letter for the Home Office explaining the size and number of people living in his home, and that he could no longer support Co Brown, who was putting in an application. Baba said that he was not prepared to disclose his personal finances to the Home Office, as this was private information. Lawyer, Court's request for fee waiver was rejected, and he contemplated judicial review. That's why I was asking the question. And I've given three likely outcomes if Co Brown went for judicial review. And what I have said is that as Baba did not disclose his financial condition, this affected Co's application. Baba is a good Samaritan, so he cannot be asked to provide his personal information. And then the third scenario I gave, or the third possible answer I gave, was that as this is Co's fee waiver, he does not have to provide Baba's information. Maybe I'll ask you to hold fire on this one, because I want to find out what answers people will give.
Right. So what we'll do is that we'll get back to this to offer the context, because if people are going to be on point or out of context, it will be based on the direction we provide. And so we are going to get back to this and let people have the context to be able to respond within that context. So producer will help us later on in the course of the proceedings with that context, so that it will offer perspective to our viewers.
All right. Thank you very much for your understanding, and we'll come back to that. And another aim of this program, so to speak, is to empower people so they understand the law and also not fall foul of some of the quack explanations that people give when it comes to the law. When it comes to BWF solicitors, you have a trusted partner. And of course, they will give you the very best of situations and answers based on the context, as lawyer has mentioned earlier on, and the directives as it is that you might receive, so you can answer some of these questions correctly. Empower yourself. Stay on, because we're coming up with our discussion for the afternoon. And as I said, Lawyer Charles Asma is going to lead us to look at the situation where we have several means of meeting the financial requirements when it comes to UK visa. Where are we broadcasting to and from? We are on Facebook and YouTube at BWF Solicitors and at BWTV. Catch that.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. I mentioned earlier on that we're going to look at different ways of meeting the financial requirements when it comes to a UK visa. And why financial requirements? Why do we need that amount of money that may be mentioned? And if I don't meet it when I earn something at the end of the month, so to speak, how do I top up? Where do I go to find extra of income to support my application? These questions and many more are on your mind, and I believe that you are ready for Lawyer Charles Asma to take us through the journey to look at the different ways. Lawyer Asma, once again, good afternoon. Thank you for joining us. Thank you to BWF Solicitors also for allowing us to have this opportunity. We're talking about financial requirements. Take us through the journey.
Right. Yes. So, viewers and listeners, good afternoon. And Bragoku, before we move into the main conversation, different financial requirements. Financial requirement, as you know, is part of the immigration application requirements, what we call eligibility. Eligibility is mainly about relationship, it's about if it's employer work related, it's about sponsorship. If it's about studies, it's about sponsorship to study. If it's about family, it's about whether you meet a specific family requirement and so many other things. But the key aspect of the eligibility is financial requirement, whether you meet a particular threshold. And a lot of people are refused because they may not meet the financial requirements to be able to help them maintain themselves in the UK. But as I said, we will have to look at the context of the question you posed as part of the quiz. So, producer, if you are ready with the context, can you please share with us so that we'll have an understanding of the context? And you, Braco, could you pose that question again?
Okay. Let me read what we have on the screen at the moment. When applying for a fee waiver or change in no recourse to public fund condition, the Home Office must be satisfied that the third party support you rely on has provided evidence of their means and income, including 6 months bank statements with explanation of all entries over £100. Most third-party support providers do not like being asked to disclose their private information when they are not the applicant. Therefore, applicants must always disclose to the support provider that they would be called upon to provide private information and evidence. There is not, therefore, anything unlawful or irrational or irrelevant in asking for further evidence from the third party supporter. And this is from the case SAG and ORs versus the Secretary of State for the Home Department, England and Wales High Court case 2984, admin 2024. Lawyer.
Yes. So this is the context of the question you posed earlier about is it Baba? And so if somebody is making a fee waiver application and they rely on a third party means a friend or a colleague, and this third party or even a family member. And if this third party is the one providing them financial support, and the third party given has given information or instructions or permission for their information to be provided that they are helping this applicant or fee waiver, the person requesting for the fee waiver, the third party sponsor or supporter can be asked to provide information to confirm what the person is claiming about them. So if the person says that the third party provide X amount, third party should be able to provide information, including their bank statement, to show how much they earn, if they will be able to support this person or not. The fact that the person is a third party and not the applicant does not mean that the law does not expect them to offer themselves for scrutiny. And so, if a third party is helping you, the law says that you have to tell them that in case they ask you to provide information relevant or specific to you, will you be willing to provide?
Mhm.
If they will not be willing to provide, then they may have to think about whether to provide the information at this stage to support your application or not. And that is
Okay.
what the court said in 2024 in the case of SAG and others versus the Secretary of State. And this is, as we saw, 2024 ruling. So
Well,
if the third
first,
party can say no, it is not mine, and so
uh-huh.
can't be bothered. If you agree to help, be prepared to support to the end.
Yeah. So, viewers, a lawyer has given you some context to the question I posed. I threw that one in a vacuum, but he situated it so very well. So it will help you answer it. So look at that, think about it. I'll show it to you later on in the program. Then I'll ask you to give me the likely outcome of the judicial review if COPE decides to toe that route. Well, lawyer, we are looking at the conditions that really people must meet for them to qualify for a UK visa of various types. And one of them, as you have mentioned, and in the topic, we're looking at the finances. Um, the rationale behind it and how we can meet those requirements are things that we have brought before you. So, yes, we will sit back and listen to you, the rabbi.
Pleasure is mine. And in this synagogue, we are going to be looking at the episode of UK visa
Mhm.
request
Right.
and whether you need to show that beyond the visa, you have to be fed or you can feed yourself.
Okay.
And that's the context of this financial requirement conversation. In that, once you request a visa to enter the
Mhm.
UK or remain the UK, do you have to prove that you can look after yourself or not? If you cannot
Okay.
prove that you can look after yourself, what will the government do or say? And so every visa category will have this financial requirement, wherein the applicant will have to prove their ability to maintain themselves
Themselves. Okay.
beyond the visa grant. And whether you came in as a visitor, or you are entering as a student, or remaining as a student, or
Okay.
entering as a student dependent, or remaining as a student dependent, or entering as a skilled worker or dependent, or remaining as a skilled worker or dependent, or entering as a family member of somebody with settled status or indefinite leave to remain in the UK or citizenship in the UK, or somebody who has 2.5 years visa in the UK and joining as a dependent. All this will require you to prove that you can maintain yourself either through your own means or through your family member sponsors means or through a third party sponsor means. And these are the things we'll be looking at. And remember, I mentioned visitors, I
Mhm.
mentioned student, I
Mhm.
mentioned skilled worker, and I mentioned family or members of people in the UK on indefinite leave to remain or citizenship. And of course, we'll add EU nationals who are
As
joining their
well.
family members in the UK. So five key categories. And therefore, we are going to be taking each in turn. But suffice to say that possibly after the commercial break, we'll just start with visitors visa whilst producer is putting the resource in order for us.
So yeah, the categories: visitors, family members, EU, skilled workers, and
Student, student.
and students, so to speak. So yeah, get yourself ready. If possible, invite people to come join us, watch this live. Or if you are not able to watch us live and you may have to pop out one way or the other, you come back to meet the link there at BWF Solicitors and at BWTV. We'll take a quick break and give you some message from BWF Solicitors. And when we come back, we start the discussion in full.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Thank you for sticking around and thank you for staying and thank you for sharing as well. So we are looking at various other ways of meeting the financial requirements when it comes to a UK visa. Lawyer Charles Asma is our resource person and guest, and he has indicated that we're going to look at five different scenarios. And we'll start off with visitors visa. What financial requirement do we have to meet when we put in an application as a visitor to the UK? Last man.
Thank you very much, Brakuku. So, for visitors visa applications, we are looking at Appendix Visitors Rule. Appendix Visitors. So, the rule book for the caseworker is Appendix Visitors. And anybody entering the UK, you have to show that you can fend yourself or fend for yourself once you have entered the UK so that you do not become a burden on the state and a drain on the public fund. So, how do you prove to the caseworker that you'll be able to survive whilst on visit? Now, with this, there's no particular amount of money that you have to show as far as visitors' visa applications are concerned. And therefore, it's a common sense and logical conclusion that you have to draw. We are going to take a scenario to be able to address this. Having been able to show that you are a visitor, you return, you also have to show that you can survive. So, producer, if you can put Brakoku on maybe at the top or wherever, side by side for me, so that we'll have a conversation on that note. So we are looking at a visitor who is entering the UK. We are going to do, yes, very good. Thank you. Thank you, producer. Grateful. So, Rakoku, you are entering the UK as a visitor. And we are saying that you have to show the financial requirement or meet financial requirement. But the rules do not give specific amount that you have to show as a visitor. And they are saying that use a common sense approach.
Right.
Because if you don't, they will still come back and tell you that you are not able to prove that your financial circumstances are adequate enough to support your claim of visiting the UK. How do you do that? Let's take an example. You are going to visit the UK for whatever purpose, and they ask you on the application form, how much is the total cost to you?
Okay.
To you. The first is to you, the applicant. Let's say you say the total cost is X amount. How do you know how much you pay? You have to carry out a budget on that project, true or false.
Yes, true.
So, what are some of the key things that go into visiting the UK? What are some of the key costs?
So, if you're coming on your own, your accommodation.
So, this is one person's conversation. So, accommodation, like we are assuming that the person will be visiting a friend or a family member, and so accommodation is catered or paid for.
Paid for.
And so, accommodation in this case, in terms of cost, will be zero, right?
Okay.
Because somebody invited them.
Somebody would be
Very
hosting
good.
you.
If the person was not invited, then the person will have to show accommodation in terms of hotel or Airbnb.
That's right.
So if the person is invited and accommodation provided, then accommodation cost is zero.
Zero.
If the person is not invited but entering the UK as a tourist, and they will provide their own accommodation, then we have to know the cost of Airbnb or hotel. Let's say Airbnb or hotel for 10 days or 2 weeks, or the period the person will be in the UK for, give and take, is, let's say, £500. Example, £500. Let's assume that a night is 50. And so the person will spend 10 nights. And so £500 in that sense. So you have noted down one cost component. What's the other cost component as a visitor to the UK if you are paying everything yourself?
Your feeding.
Your feeding. So let's assume that this Airbnb or hotel does not include feeding. So you have to provide your own feeding or boarding. In this case, let's assume that you'll be buying food, breakfast, lunch, and dinner. Give and take, spending about average of, let's say, £25 or £30.
About 30 pounds, yeah.
£30 a day for 10 days. That gives you how much?
Another £300.
So we have 500 for accommodation, 300 for feed for that period. Then what else? What's the other cost component?
So your transportation, where you commuting to and from
UK and back. So your transport to UK and back, that is to the airport alone. So from wherever you are coming from, arriving at the UK airport, that alone, let's give and take, let's say $1,000. Converted to pounds, let's say £800. Somebody will say, well, I'm going to go for the cheapest, but let's go for the realist amount. So £800. 800 plus 800, isn't it?
Yeah, then £1,600.
600. Then we move on to something else. Yes, from the airport to your place, you'll be visiting places you claim. And so there's going to be other costs on transportation as you are in the
As you
UK.
are in the UK, yes.
And so, give and take, let's say that one you can't really tell how much. Uber. So we use Uber component, we use bus component, we use train component. And let's assume that if it is bus, depending on where you are living and where you be going, let's have a budget of, let's say, £200.
Okay.
That
So
one
that makes
is
it 1,800.
exactly, yeah. So that makes 1,800, right? So
Yes.
we've covered four key components, cost items. Cost item number one is accommodation. Item number two is feeding. Item number three is the flight. Item number four is the in and out
Internal transportation.
transportation. All right. Four. Then you are visiting the UK. Anything can happen. So you have what we call contingency money, right?
Mhm.
Yes. In case of emergency, you have made a provision for, let's say, and that one, you can look at the total and have a provision of, let's say, 20% of the total.
Mhm.
And so the total so far is how much? 1,800, right?
1,800.
20% of that, 18 times
80
2,
plus 18, 360.
and that is 360. Let's keep it simple. Let's say £200 for other things,
Mhm.
making £2,000, right?
Yes.
So this person is entering the UK for 10 days holiday, and they say they are spending £2,000, but they are paying for everything themselves. Question is now show how you are going to fund this, right?
Mhm.
And how you are funding it, if you are not being sponsored by anybody, should come from your own earnings. So if you are working, your monthly salary, then we have to convert it to the local currency.
Mhm.
If you are in Nigeria, converted to Naira. If you are in Ghana, converted to Ghana cedis. If you're
Mhm.
in Jamaica, America, wherever, of course, America you wouldn't need unless, of course, you don't have you are not a citizen and you are coming. Then, of course, you still have to show. So you convert it to the local currency to be able to get the local amount you have as part of your
Of
earnings.
your budget, yeah.
If it is Ghana, for example, then we'll say that £2,000, give and take, is 2 times 15 is 30. That's about what? 30,000, isn't it?
30,000 Ghana cedis. Yeah.
30,000 Ghana cedis. And let's assume that this person works and earns, let's say, 5,000 Ghana cedis a month. What the person is saying is that I am going to spend 5 times
My monthly salary.
my monthly earned income on this trip for 10 days. We are talking about logic here and
Mhm.
reasoning. And so the caseworker will say, okay, you work and you earn equivalent of, you earn 5,000 Ghana, which is, if you were to be converted to pounds, we won't do the pound calculation, but what it means is that if it's 30,000 is a monthly in terms of your £2,000 for the trip or cost for the trip, then this 5,000 is what? 5 over 30, which is 1/6.
Mhm.
1/6. So if you are getting 1/6 of the total cost a month, how can you
How can you
survive
convince and
once you
survive?
return?
Convince me to survive
Exactly. Once
for
you
the
return,
10 days that you are in here.
exactly. That means you have to save for 5 months, right?
Mhm. Without spending any amount from your earnings.
Exactly. For example, you have to save for 5, 6 months without spending anything. Then they ask you, how much is your regular expense in your country where you live? You talk
Mhm.
about your rent, you talk about your feeding, you talk about everything else. And let's assume that that also takes so much of your monthly salary. So let's say your monthly salary is 5,000 and your other outgoings on a normal month is about 4,000. So you are left with 1,000, right?
Mhm.
How can you survive on this trip with a savings of 1,000? And 1,000 will be about 30 times.
30 times
So you have to
what you
save
need
for
to survive for 10 days
exactly.
here in the UK.
So you are the case worker. We are not talking about law, we're talking about common sense and logic. If you are the case worker applying your common sense and logic, will you consider this person to be somebody who will be at risk of not able to survive either in the UK or when they return?
Mm-hmm.
Will be at risk of financial challenges, right?
Yes.
When they don't even have enough in terms of earnings. How can you fund £2,000 with 5,000, which is 5,000? Give me a simple calculation. If it is 10, would have been 500. It's 15. Give and take, give me about £300.
Mm-hmm.
So you earn £300 and you are going to spend £2,000 for 10 days. Meanwhile, that 300 you earn it for 30 days. Is that logical?
Yeah.
Is that reasonable?
Is that reasonable?
Is that commonsensical? And if that is the caseworker will conclude that on the balance of probabilities, you've not been able to prove that your income is able to do A, B, C, D. And the inference will be that you are more than likely not to return to your country. You are looking for an escape.
So, Laura, in a situation like this, that the person's provided their bank statement, pay slips that shows how much they earn in a month. But if over the period before they decided to embark on this UK trip as a visitor, they have made some savings that they can provide evidence of, would that be an alternate source of income that they could use to support their application?
So this person will now say that I have cash savings of, let's say, £10,000 equivalent. And I'm using 2,000 out of it, which is 1/5 of my money.
Mm-hmm.
So if I'm using 1/5 of my money for a good cause, i.e., traveling and coming, so that I can rejuvenate, I can recuperate, and I can focus on productivity, it makes sense.
Mm.
Considering the fact that there's somebody who is earning 10,000, or who has savings of £10,000 equivalent in their home country, will be earning more than £300 a month.
Obviously, yeah.
So if you are earning, let's say, equivalent of £2,000, let's say you are earning $2,000,
Mm-hmm.
and you are traveling, spending 1 month, that's not a big deal. And such a person will be understood that when they go, they'll return. Because if you are earning $2,000 or £2,000 in your home country, why should you waste your time abroad?
In the UK, yeah.
Yeah, but if you are earning £300 and you have opportunity to step out, will you step back?
Well, if I'm going to earn more, why not?
No. On the balance of probabilities,
Mm-hmm.
if you are earning just this and you have opportunity to step out, will you be inclined to step back easily?
To
Easily.
earn that little?
No. And that's why they will conclude that this person, from what we see, is likely not to, or she's likely not to
return to their home country.
And that will feed into the adverse inference conclusion.
Okay.
So, visitors visas, we don't have specific financial requirement. However, there's common sense analysis of your finances to be able to. If the person is being sponsored, the person will be asked, how much is the cost to you? The person will say 0. Then the person will have to tell who will be sponsoring and whether the person can sponsor indeed. In this case, it will be those people's earnings
that
to
will
do
be
the
considered.
Exactly. So that's the difference for visitors.
All right. So yes, we've cleared up the bit about the vista, and we know that there's no specific amount, as you mentioned, and there must be that common sense approach and logical reasoning behind it, and behind the evidence that you gave. And as I posed the question, lawyer has explained that if you have so much, for instance, you've been able to save £10,000 and using a fifth of that to go and kind of recuperate so you could go back to what you are doing, then you would be considered one way or the other, or it will be considered that you've taken the financial requirement. But even in that, somebody who is able to save £10,000 equivalent in their home country may be earning a lot more than the 300 that probably we used in our explanation as an example. Yes, other situations we've looked at the visitor. What's the next one we would have to look at, and what are the things that we need to unpick from that lawyer?
Right. So the first part we looked at is where there's no formula or there's no box to tick.
Okay.
Where there's no box to tick, you have to be clever in your analysis and logical conclusion.
Okay.
But where there's a box to tick, your job is to tick the box
The box.
because that is
And
fixed
the box obviously will be a criteria that you need to meet.
within the rules. Yes. So visitors
Yes.
visa, we don't have criteria for financial requirement, but other visitor categories we will. So let's look at the next one. Let's look at student.
Okay.
Producer,
So
student.
I am a student, or I am traveling from, say, Nigeria to school here in the UK. Obviously, you would need to have some money to cater for yourself. Thinking you'd have to think of your school fees, you have to think of your accommodation, you have to think of your feeding, you have to think of some other forms of maintenance, at least for the duration of your course. Am I right, lawyer?
You are right. And so, as part of the student visa application process, one of them is the financial requirement. And producer, take us down to the financial requirement. So go under eligibility, open up eligibility, and scroll down to ST12. 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 Go down 12. 12. 12. 12.
Yeah, 12. Yeah,
Hey,
financial
yes,
requirements for a student.
yes.
That's
Good.
ST12
So
1.
that is the jacket set for a student. Let's see if this jacket will fit the student. And if it doesn't fit the student will fail on the financial requirement.
Okay.
And this
Let's
also
whisk
applies
through that.
standard.
If the applicant is applying for permission to stay and has been living in the UK with permission for 12 months or more on the date of application, they will meet the financial requirement and do not need to show funds.
Full stop.
Yeah.
So if the person is applying from the UK as a student and they have already lived in the UK for 12 months, let's say they were on one category and switching to student category, and they've been living in the UK for 12 months and working, then that is automatic. They don't have to show financial requirement. The presumption is that they are living, earning, and looking after themselves anyway, and therefore the status quo will remain.
Okay.
You can see that there is some sort of sympathy in that policy for those people. Yeah. Right.
Obviously, they would have met the requirement at the point that they entered and have stayed here for 12 months. So if they didn't meet it, they wouldn't have been able to survive for 12 months. I think that might be the reasoning.
One. And the other one is that if they're already in the UK on any category, but they might have been here on a different category. And so if they're already here and working and earning and looking after themselves without recourse to public fund, then presumption is that they can continue as such.
Okay.
Yeah.
Now let's look at 12.2. If the applicant is applying for entry clearance or permission to stay and is applying as a student union sabbatical officer, they will meet the financial requirement and do not need to show funds. That's a bit technical. What's that?
Yeah, so this is where somebody will be entering the UK on sabbatical leave. Sabbatical, most of the time, they will be given stipends to travel and come back. So accommodation, maintenance, everything catered for.
Okay.
For those people, it's met, and so they are okay.
Okay.
Yes. Let's look at those without protection.
All right. So 12.3 gives a caveat. And it says if ST12.2 does not apply, and the applicant is applying for entry clearance or is applying for permission to stay and has been in the UK with permission for less than 12 months, the applicant must have the following funds. And it stipulates that studying in London, it looks at the type of study and the funds that are required. Residential independent school, sufficient funds to pay outstanding fees, course fees, and boarding fees for one academic year.
So one academic year will be calculated for you, and they will give you the pound equivalent. And
Mhm.
so, for example, in the all other cases, the pound equivalent is this and what 1,529 for each month for the course, blah blah, blah, up to what maximum
A
of nine
maximum
months.
of 9 months.
So if we multiply 1,500, let's take out the 29 for
Mhm.
simplicity. 1,500 by 9 months, and again let's make it 10 months for ease of calculation. Then
So then that's
1,500
15,000.
will be 15,000. So give and take almost 15,000 pounds, isn't it?
Mhm.
So all other categories, 15,000 pounds for the duration of study.
Okay.
And so if you are coming, if you find yourself in that category, on top of your accommodation and your student, your tuition fee balance, you have to
Mhm.
show that you have money on the side for 9 months of your feeding. Somebody
Okay.
will say that, but lawyer, when they come, they are coming to work. Why should they prove that money for feeding? They are not coming to the UK to work. Otherwise, they would have applied for a skilled worker visa.
They
They
come
are
to
coming to
study.
the UK to study. And so work is just accidental. And for
Then
the
I think the
dependent,
question that may be asked is, what if a few months into you or your period of study, you still haven't found a job that will give you the 20 hours that you are required to work? What
for
happens?
example, because yeah, that's also a risk factor to be considered so that you can have everything ready before you come. So that even if you don't find job and you are a serious student with the aim of learning every day without distraction, then you have enough money to look after yourselves without any challenge in terms of financial needs. Now, the same applies to the dependent.
Okay.
Dependents are also coming to the UK to join the main student.
Yeah.
Somebody will say that, but dependent will be working. The dependent is not in the UK to work. You know why the dependent say they want to be in the UK? Dependent says that they want to be in the UK to give moral support
To the
to the
applicant.
staff who is studying. So whilst they are studying, they will be preparing the food. They will be singing to them. They will be looking for materials for them to study. Because you are here to live with them,
Mhm.
not to work and look after them. And so, if you are coming as a dependent and you don't have the enough income required within the bracket, and you say that, but when I come, I will after my spouse, we'll look after ourselves because I will be working. You are wrong, because you are not into work. If you are into work, you would have come as a skilled worker dependent.
Worker. Okay.
So, so if it is clear that you have to find X amount and you don't get it or have it, then it will go against you. Again, let's go to ST126. Producer, ST126.
So FT126 says that the applicant must show that they have held the required level of funds for a 28-day period, and as specified in Appendix Finance, unless the applicant is relying on a student loan or official financial sponsorship, which meets the requirements of FIN 8.3 in Appendix Finance.
Good. So Appendix Finance paragraph FIN 8.3 is the reference point to 12 ST126. So ST12 says that if you are coming in as a student and you have calculated that you need, for example, 15,000. That is if you are not sponsored. If you are
Mhm.
sponsored, your sponsor will tell that the money is provided. But if you are self-sponsored, you need that money for your 9 months feeding. That money should be in the account for 28 days.
Mhm.
So the caseworker will check to see whether the money was sitting in the account for 28 days.
28 days.
If the money was not in the account for 28 days, then you cannot meet the requirement under ST, paragraph ST 12.6 of Appendix Student to the Immigration Rules. Somebody will say that, oh, my lawyer, okay, that's what that one, there's not a big deal. I will keep the money for 28 days. And soon as I make my application, I will
I'll
withdraw the
withdraw
money
it.
for another purpose. Somebody can think like that.
Mhm.
Those who are thinking like that, the answer is found under paragraph ST 12.7. What does ST 12.7 say, Brakoku?
It says if the funds held in the applicant's account on the date of decision falls substantially below the level of funds required at 12.3, the decision maker must be satisfied that the spent funds have been used to pay outstanding course fees, a deposit for accommodation, or other costs associated with the proposed course of study in the UK.
Good. So it says that those people who will use the money after they have submitted their application, but the caseworker did not make the decision before the money was withdrawn,
Mhm.
and the caseworker finds out that the money has been reduced. It was 15,000. The person has spent 10,000 and they are left with only 5,000. And by the time of decision, caseworker has picked that up. The caseworker is saying that show that the money you took from what you said you have was for accommodation, or was to pay your outstanding tuition, or was for any other relevant cost to your study. And that is where the lacuna is. So here, what we are saying is that if you withdraw the money before a decision is made, it will go against you, unless you can prove that the money you drew from the maintenance fund was for a purpose relevant to the studies or the course of study, the cost associated with those studies. Otherwise, the application will be refused and you'll be told that you have not met the maintenance or financial requirements.
Well, that's for the student bit.
Skilled
If
worker.
you're not able to meet that, then it means that your application may not be looked at or be refused. Is the financial bit the all in all in getting the application granted?
For students, yeah, it is set out in stone. For
Okay.
visitors, it is not set out in stone. So that is logical conclusion. So student, it's clear. And if you meet the requirement or you tick the box correctly, that is it. You've met
Okay.
it.
All right.
Now let's go to skilled workers,
Okay.
because the conversation is financial requirement for different visa categories, isn't it?
Categories, yes.
So if we look at two categories, we are looking at the third one, skilled worker. Producer, help us here.
So we're going to look at what the guidance to the caseworker will be when it is that they are giving a skilled worker application to consider. And financial requirements is one of the bits that they consider. So skilled worker case worker guidance, and it we have the version 18.0 of that. Um, so we're going
Producer,
to look at eligibility for entry clearance and permission to stay applications, I guess.
very good eligibility. So paragraph 5, please. Producer, click paragraph 5, yes. And under that, we go down to finance, scroll down to financial requirement. Okay. Okay, scroll down a bit. Let's see if we'll find it there. Financial requirement, English
English
language,
language, tradable
tradable
points.
point. It's a lot for this, so just keep
I
going
know.
down. Right. Okay. I mean, there's so much for skilled workers, but again, the conversation is similar to that of student. It's similar to that. We wanted to be clear on the specific amount, but we have to just go sift through. But for viewers and listeners, if you are looking for the financial requirement for skilled worker visa, again, that is the policy guidance. What you do is scroll down to where the financial aspect is. There's so much, and so you have to take your time to find that. Once you find it, it will tell you that the amount required is
I think we may have located it, and for purpose of reference, let's see if we can look at that. And it's paragraph 19 of that. And it says that this section explains how to assess the financial requirement previously known as maintenance for skilled workers. An applicant will automatically meet the financial requirement when they are applying for permission to stay in the UK, having been in the UK for at least 12 months with permission on the date of application. I think that has been explained. When the above does not apply, an applicant can meet the financial requirement by either their sponsor providing they are A-rated, certifying they will, if necessary, maintain and accommodate the applicant up to the end of the first month of their employment to an amount of at least 1,270. Then also providing evidence showing they have held funds of at least 1,270 for a 28-day period as set out in the financial requirement guidance. This has reduced from the 90-day requirement which existed for tier 2 applications.
Thank you. Thank you. Yes. So, Bragoku, I think this is clear enough. Again, as a skilled worker, if you have to provide the maintenance because you have not been in the UK for 12 months, or your main spouses or the company sponsoring your main applicant has not guaranteed the maintenance, then you have to show 1,270 for 28 days period prior to the date of the application. And so let's bear in mind. So if this is not met, let's say the person had the money for 25 days and they needed to pay their rent or there was overdraft and the money was taken from the account, will they meet the requirement?
No.
No, because it is not up to 1,270.
270.
Example would be somebody who is switching to skilled worker as a student for the first time, or from PSW moving there, and they haven't lived in the UK for up to 12 months. They have to prove it. Or they are coming from abroad and the employer is not guaranteeing maintenance. They have to prove that in the account. So let's be very, very careful. Comparing this to student, producers scroll down to see whether if the money was taken before a decision, it will affect them. No. So that's it. That's producer. That's it. That's the end of the matter. It doesn't say what will happen compared to student where it says that if you withdraw the money, it will affect you. For skilled workers, if you withdraw the money, it doesn't affect you, provided you make the application before the money was withdrawn.
Right. So yeah, for us, we have looked at three of them so far. Student, we've looked at the visitors and the skilled worker. Now let's look at the next category, lawyer.
So the next category will be the general appendix FM applicants. Applicants who are applying to enter the UK as spouses of people who are British or spouses of people who have indefinite leave to remain in the UK, or spouses of people who are EU family members or nationals, but they are not applying under Appendix EU. So if they have to meet the financial requirement, then it will be the financial requirement under Appendix FM, what we call specified evidence under financial requirement. So, producer, go down for us and eligibility. Okay, fine. So family life with a partner is there. Scroll down to see if there is specific information about financial requirement. Relationship is there. Good. Scroll down after relationship.
The financial
Financial.
requirement comes up in ECP 3.1,
Yes.
and
So
it says that
easy.
the applicant must provide specified evidence from the sources listed in paragraph E, ECP 3.2.
Yeah,
A
Brakoku.
specified gross income of at least 29,000, specified savings of 16,000, and additional savings of an amount equivalent to 2.5 times the amount, which is the difference between the gross annual income from the sources listed in paragraph EECP 3.2, that is A to D, and the total amount required under paragraph EECP 3.1A, or the requirements in paragraph EECP 3.3 being met. So
Okay.
3.2 says when determining whether the financial requirement in paragraph 3.1 is met, only the following sources will be taken into account. A, income of the partner from specified employment or self-employment, which in respect of a partner returning to the UK with the applicant, can include specified employment or self-employment overseas and in the UK. Then it goes on to give us B, specified pension income of the applicant and partner, and C, any specified maternity allowance or bereavement benefit received by the partner in the UK, or can you scroll up a bit for me, please? Or any specified payment relating to service in His Majesty forces received by the applicant or partner.
Okay. So yeah, so as you read through Brakoku, you see that, but we are going to break it down for the purposes of learning.
Mhm.
EC means entry clearance. Eligibility, EEC means eligibility for entry clearance.
Okay.
And P is partner. If it
Okay.
is PT, is parent.
Okay.
So EC entry clearance. If it is not entry clearance and it is in country, we will see limited leave to remain, LTR. So when we see ELTR, it means eligibility for limited leave to remain. That is in-country
In
renewal
country.
or
Okay.
in-country switch. So that's the difference. So this is somebody coming from abroad or somebody applying from within. It says that it is again check box, and you have to tick those boxes.
Okay.
So the first box is that you are earning and your income before tax is 29,000. Either the 29,000 is from you or from your sponsor. It doesn't matter. If you are not earning up to 20, that and again you can combine the two, both of you up to that. If it is not enough, you can rely on savings. Savings, you have to look at 16,000 as the first savings, plus additional savings of the salary you are on from the salary that you must be on times 2.5. The salary you are on is your actual income. The salary that you must be on is the 29,000. And the difference multiplied by 2.5, you add it to the 16,000. And that will show savings. So if you can't meet the 29,000, you can rely on your savings, but that is a high threshold. And in terms of sources, it can be self-employment, it can be this, it can be different sources of employment. But for us, all we are interested in is that if you are applying as a partner of somebody with indefinite leave to remain or somebody who is a British citizen, you must show that your income meets the tick box requirement. That
Okay.
is that. Okay. Now
Oh,
we will move from here
mhm.
to look at armed forces. Armed
Okay.
forces again under appendix FM. Armed forces. Armed forces. Producer, armed forces. Okay. So these are people whose spouses are serving in the army. What is the
Okay.
financial requirement for army wives and husbands? So that's page
Page 11, I
11.
guess.
Okay. So Bagoku, over to you.
So calculating the minimum income requirement, following the changes to the minimum income requirement MR of April 11, 2024, different thresholds apply to applicants depending on the date the current application was submitted, when the applicant first successfully applied to the route, and whether they are applying under Appendix FM or Appendix HM Armed Forces. In summary, Appendix FM, the thresholds must be applied as follows. Those who apply on or after 11 April 2024 who are new to the 5-year partner, fiancé or fiancée or proposed civil partner route, who are applying for permission to stay with a new partner, must meet the £29,000 threshold. Those who apply on or after 11 April 2024 who are already within the 5-year partner, fiancé or fiancée, or proposed civil partner routes and are applying for permission to stay with the same partner for which they were last granted permission, benefit from transitional arrangements, they must meet the lower threshold of £18,000 plus the child component, cut at a maximum of 29,000. Then those who apply before April 11, 2024 must meet the previous threshold of 18,600 plus the child component where relevant. There is no cap in place for this cohort. And then finally, a child applying under Appendix FM must meet the same threshold as the parent they are applying to accompany or join, regardless of the date of the child's application. Lawyer.
Right. So for armed forces, it's also clear. So if you are applying as a family member of of a serviceman or servicewoman, it's also set out clearly for you, similar to that of Appendix FM dependents. Now, the difference between the 18,600 and the 29,000 is that from 11th of April 2024, the money changed from 18,600 to 29,000. If with the 29,000, you don't have to bother about how many children are included. But with the 18,000 previously, you needed to add each child specific amount to that. But the key thing is that if you are renewing based on 18,600, you continue to use 18,600. And if you are renewing based on 29,000, you have to show 29,000. If you are applying today for the first time, you have to use 29,000. So, Brakoko, you realize that so far we've looked at all the people that are spouses under Appendix FM. What about the person is applying under Appendix FM as a parent or as a spouse? If the person is a spouse, and the spouse that is sponsoring them is on personal independent payment benefit as a disabled person who is on benefit for PIP, then there is no financial requirement, 29,000. You just have to show how much is your benefit, and you have to check to see whether after paying your rent and council tax, the money left is enough, equivalent to somebody who's on a standard benefit a week. And the standard benefit a week, or let's say a month, it's about 1,865 for people who are within London. And those outside London is a little cheaper anyway. So, what about people who are applying as parents? If you're a parent applying on the basis of your child, then you can rely on Appendix FM paragraph EX1 and Gen 3.2. Those ones are exceptional circumstances. And anytime you are applying based on an exceptional circumstance, you don't have to meet all the requirements. And so if you don't meet the financial requirement, then you have to prove that you meet one of the exceptional circumstances, i.e., there is a child involved, or there is a spouse or a partner who is in such a situation that if you are removed from the UK, it will affect their survival. That is what we call insurmountable obstacle. Or the child is in the UK, and if you are removed because you cannot meet the financial requirement, it will affect the well-being of the child. So when you are applying under EX1, you don't have to show financial requirement. That is why we say that if you are an overstayer, you are applying based on your child, you don't have to worry about the finance because you don't work anyway. So how can you still survive? You survive because you'll be given the visa under 10-year route instead of the 5-year route. And later you can switch once you meet the maintenance requirements or the financial requirements. And so those who do not meet the financial requirement, the assessment will be based on the case of voodoo. Voodoo means VOO, or is spelled as VOODOO. It's a court case where assessment of maintenance or finance is based on adequate maintenance, your ability to pay your rent, pay your council tax, and look after yourselves without recourse to public fund. If you're able to prove that, then your application will be granted on the basis that you have met the maintenance requirement. So these are the nitty-gritties as far as the financial requirements for different visas are concerned. The last part will be Appendix EU. Do you have to show financial requirement for Appendix EU? Now, Brekoku, let's have this brain teaser. So, producer, put us side by side. We are going to have this brain teaser. Brekoku, I'm going to give you the context.
Okay.
And you will tell me whether financial requirement must be compulsory or not.
Okay.
Under the EU provisions, there was a treaty agreement between EU and its member countries in the 1950s, 1960s, what we call the EU Treaty Agreement.
Yeah.
All those EU countries that signed up to that were able to have their nationals move freely without any restriction. And that is called free movement of people and free movement of goods and services. That is why before, some people go to Germany, France, and buy goods and come and sell in the UK. Free movement of goods and services. All of a sudden, UK says that I'm sick and tired of this union. I'm better off alone. So Brexit. And so a law was passed called Withdrawal Agreement 2020.
Yeah.
And the agreement says that from this point, and what is that point? 11 p.m. of 31st of December 2020. From this point onwards, we are no longer part of Europe. But the question now is, what becomes of the agreement that existed before you change your mind? You go with it or you leave it behind. And that is the meaning of the withdrawal agreement. So they have to redefine the agreement. And they said that all EU nationals who want to remain in the UK can continue to remain in the UK based on the existing treaty agreement. Mind you, the existing treaty agreement does not talk about conditions, including financial condition. And so if the agreement will continue post-Brexit, can there be any introduction of financial requirements for any EU application? No.
No.
Yes or no?
No.
Otherwise, that would be a breach, right?
A breach, yeah, because
of the withdrawal
the
agreement.
doesn't specify it should be altered.
So there's no fettered condition. That's one point. Then, if we are talking about somebody who is making an application to stay in the UK for pre-settled or settled status, or to join a family member who is in the UK under EUSS family permit application, should the UK say they should meet financial requirement or not?
That wasn't part of the agreement, so no.
That is not part of the agreement. And so if you decide to introduce something, that will be a breach of agreement. And so UK is careful not to touch EU nationals and their family members. And that's why we say EU is an amnesty application. And so when we are talking about financial requirement for different categories of visas, can we touch EU visas?
No, because there's no agreement.
And therefore, there's no financial requirement for EU pre-settled and settled visas. Full stop.
Well, folks, do you need to have any different advice from what I'm going to give you? If you are a layperson, it is best for you to give your work for an artisan to do for you. And when it comes to immigration matters, when it comes to legal issues, I would advise unequivocally that go to BWF Solicitors, the trusted partners when it comes to the law. They're located on the fourth floor of Vienna House, 214 to 218, Tottenham High Road, Seven Sisters, North London, N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can reach out to them on telephone number 0208 493 7340. 0208 493 7340 or 077 127 61884. And if you want empowerment, if you want to have any question answered for you when it comes to the legal matters, especially immigration issues, like a very technical one we have discussed this afternoon, then join us every Saturday afternoon between 4 and 6 p.m. UK time on the program The Community and the Law Live on BWTV. This afternoon, we've done justice to looking at different ways of meeting the financial requirements for a UK visa and for various categories. And Lawyer Asma is still here. We still have some time on our hands to answer some questions if you really want to pose any. The telephone number is 0208 493 7345. Or you can send in a text to our text number, which is for WhatsApp and text messages, 07399 208 468. 07399 208 468. Or you can leave them in the comment section down below, either on Facebook and YouTube at BWF Solicitors and at BWTV. Once again, my name is Oreku Frimpon, and my resource person and guest this afternoon has been Lawyer Charles Asma from the stables of BWF Solicitors. Let me just reiterate just my social media handles, and we'll pick up your question. And remember, I gave you a scenario of that person that had a third-party supporter who decided to withdraw their support, and then again it came up that they needed to provide some details which he wasn't prepared to provide. This person's fee waiver application has been refused, and he wants to go the judicial review route to see if the decision could be reversed in his favor. We're talking about Baba Samo, who decided not to support Cole Brown again. What is the likely outcome if he decides to go for judicial review? Are we saying, as Baba did not disclose his financial condition, this affected Cole's application? Are we saying Baba is a good Samaritan, so he cannot be asked to provide his personal information? And as this is Cole's fee waiver, he does not have to provide Baba's information. Social media handles, and we'll be right back to pick up your questions. Well, thank you for sticking around. So let's see what questions you have. As I mentioned, the lines are open as well. 0208 493 7345. Lawyer Asma is still here with us. I'm listening to the program on Facebook. Thank you for that. My question is, I have a spousal visa. My partner lives in London and I live in Nottingham with different address, isn't it going to affect my visa? Lawyer,
Okay, what's the key word there? The relationship word
spousal
in the
visa.
question
They live
is no
apart.
partner.
Okay, yeah,
Partner is the key word, isn't it?
yes.
What do partners do in terms of accommodation?
Ideally live together.
Ideally live together. That is called subsisting relationship.
Mhm.
Now, from the story, they don't live together because one lives in
In
London and
London,
the other
and
live
the one lives in Nottingham.
in Nottingham, regardless of the reason. Nobody cares about the reason. If you are not living together, the conclusion is that there is no subsisting relationship and the application will be refused.
Well, my friend, yes. That's your answer. Anyway, that's that's what I would say. Naima comes in. Y'all came to the UK in April 2023 as a dependent husband of Mary, who is a care worker. Their marriage broke down in March 2024. Lawyer. Mary obtained a divorce certificate dated May 2024, but she has not yet informed the Home Office. Y'all has since met another woman who is also a care worker on the SOC 6145 route. He plans to marry her and then apply as her dependent husband in May 2026. Three questions. Can y'all use the divorce certificate from 2024 together with his new marriage certificate to apply this year, which is 2026?
So the answer is if Yao is divorced and remarried, he can apply. However, Yao must show that the relationship is genuine and subsisting, and that
Mhm.
depends on a whole lot of other factors. So the fact that he's married, the fact that he divorced, the fact that he wants to apply doesn't mean he will get a visa. He has to show that that relationship, the new relationship, is genuine and subsisting. He should also have informed the Home Office that the first relationship broke down.
Okay.
Question two.
Question two. Will the delay in notifying the Home Office about the divorce affect his new visa application?
Ordinarily, ordinarily, you have to tell them as soon as you became aware.
Mhm.
Let's assume that our friend became aware today because he didn't know. Not knowing is not an excuse, but it's a mitigation. And so if you didn't know, the key thing is that you have to notify them immediately. The worst case scenario is notify them before you put in another application. So if you didn't know and you now know, act quickly.
Okay. Then the third one, lawyer, is that are there any risks of refusal or a ban due to the gap between the divorce and notifying the Home Office? I think
That is given
you touched on that briefly, but if you could
exactly. So
reiterate.
the answer to three is given under two.
Mhm.
So if
Okay.
our friend is not sure, they can give the job to a lawyer to handle for them so that they can have their peace of mind.
Well, Naima, what I would recommend, listen, pick up BWF solicitors number and contact them. For me, that's my recommendation. But lawyer is saying give it to a competent lawyer to handle for you. But I recommend BWF solicitors to handle this for you. 0208 493 7340 is their number. I am on the 2.5 year route to settlement based on my British child lawyer. I'm currently married and living with my partner who is an overstayer. I want to support my husband in making an application based on our family life, including the emotional and physical support he provides for me and his stepchild. However, I'm worried this may affect the benefits I currently receive from the government either before or after the application. So the question is, will this have any effect on the benefits I receive from the government? Also, do I need to provide any financial evidence to support this application? Lawyer.
Okay, I think we answered the second part to this question in our discussions, where we said that if the person is applying based on a child and there's exceptional circumstance because of the child, then they don't have to show financial requirement. Bravo, remember.
Yes.
So they don't have to show financial requirement. And if they don't show financial requirement, they will be put under 10-year route. But if they are going to show financial requirement, then they will be put under 2-year, the 5-year route. We are told that the husband who may be making the application based on the stepchild is an overstayer. So this person can only apply under 10-year route because they will not meet the immigration status requirement anyway, and so they will not meet some of the requirement. And if you are not going to meet one of the requirement, why don't you add the other requirement, which is finance, and keep it simple and go under 10-year route? So that's the answer to the second question. The first question is, you see, the first question is akin to somebody who is in a lukewarm situation. They are not hot, they are not
They're not
cold.
cold.
We are bringing it home. What do we mean? Our friend our friend wants to eat her cake and still have her cake, isn't it?
Mm-hmm. Once
She
you
wants
get
to
cake and have it still.
exactly. She wants to sponsor the partner on the basis that the partner is a stepfather to the child.
Mm-hmm.
At the same time, she's worried that once my partner becomes part of me, I will lose the support the government is giving me.
Which one do you want?
Exactly. Now, this is the position. Because the person is an overstayer, they are not working. But you have to tell the government that's the Works and Pensions Department, PWD, that you are married or you have a partner living with you and you have to disclose. So you go on your benefit journal and update your record with your partner information. They will pick up the partner information, including income. Your partner is not working, so the income will still be zero, isn't it?
Yeah.
And so the benefit assessment will remain the same because zero plus whatever you are having will remain the same.
Wait a second. Yeah.
And so you don't lose anything at this stage. However, once the person is given the visa and they start working, you have to go back and update the journal to say that my partner is now earning £1,000 because before it was zero, now it's 1,000. And once the income for the family changes, that will affect the benefit threshold for this person.
Mm-hmm.
And that is where she will lose the benefit. So she will have to make a decision whether money or love.
Whether money or love. Let's see what else we can bring. We're running out of time, so I will ask you to help me with answers to the question I posed earlier on about the situation Baba Samo and Cole Brown find themselves in. Now, what I said was that Baba Samo, a third party supporter, provided a letter for the Home Office explaining the size and number of people living in his home and that he could no longer support Cole Brown. Baba said that he was not prepared to disclose his personal finances to the Home Office as his was this was his private information. Cole's request for fee waiver was rejected, and he contemplated judicial review. So the question I'm asking it was the likely outcome. As Baba did not disclose his financial condition, this affected Cole's application. Baba is a good Samaritan, so he cannot be asked to provide his personal information. And the third one is, as this is Cole's fee waiver, he does not have to provide Baba's information. Which one will be the likely outcome if Cole Brown went for judicial review? Drop them in now. Let's see what you have. And Abigail Hansen says it's number 2. Baba is a good Samaritan, so he cannot be asked to provide his personal information. Portia Seydu thinks as Baba did not disclose his financial condition, this affected Cole's application. Franco Tua Champon agrees with number 1 and says, as Baba did not disclose his financial condition, it affected his application. Patrick Amisa thinks that Baba is a good Samaritan, so he cannot be asked to provide his personal information. Kujanane, as this is Kojo's fee waiver, he doesn't have to provide Baba's information. Ohima Free thinks it's number 2. Thank you, Ohima, for that. Next is from Erica Pia Kubi. He thinks it's number 3, as this is Kojo's fee waiver. He does not have to provide Baba's information. Kweku McLean says that Baba did not do the declaration, so it affected Ko. Theodora also thinks it's number 1 as well. The next one we have is Esther Asare. Esther Asare thinks it's number 3. The fee waiver application is not for Baba, so he doesn't have to provide that information. Vincent A. Michael, well, that happens to be the last one I'm picking up here. Vincent thinks it's number 3 as well. Citizen Kojo, Baba must be willing to provide his information. Lawyer, do you agree?
So let's look at the context.
Mhm.
Producer, help us with the context.
Okay, so you provided the context, I think, earlier on, and you said that when applying for a fee waiver or change in no recourse to public fund condition, the Home Office must be satisfied that the third party support you rely on has provided evidence of their means and income, including 6-month bank statements with explanation of all entries that are over £100. Most third party support providers do not like being asked to disclose their private information when they are not the applicants. Therefore,
So Rabuku, now let's situate this within the context of the question. Leave it here. First paragraph. When applying for fee waiver, that is Co, isn't it?
Yes, Ko Brown.
So when Co Brown is applying for a fee waiver, the Home Office will have to be satisfied that Baba Samo, that is the third party supporter that Co wants to rely on, will provide his personal information, isn't it?
Yes.
So that is the duty on Co if you want, duty on Baba if he wants to help Co, and Co must be aware before accepting help from Baba. That's the first context.
Okay.
Second, most people who are third parties, so we are not going to put most people, we are going to mention who? Co? No, sorry, Baba, isn't it?
Baba is a third party supporter, yeah.
Exactly. So Baba may not like to be asked to disclose his private information. That is what we were told, isn't it?
Yeah.
When he is asked to do so. Therefore, Co must always disclose to Baba that Baba would be called upon to provide his private information and evidence, including bank statement and so on and so forth.
Okay.
There is nothing wrong with Baba being asked to provide that information.
Okay.
That is why he says that there's not therefore anything unlawful or irrational or irrelevant in asking for further evidence from the third party. So there's nothing wrong for Home Office asking Baba to provide information to support Co, who is his friend and he wants to help him, isn't it?
Yeah.
That's
in the context, Baba is saying that I can't support Co anymore because of my personal circumstances, so I am withdrawing.
Well, we are told that Baba said that he was not prepared to disclose his personal finance to the Home Office, as this was private information. Whose request to the fee waiver was rejected. Where did Baba say I'm withdrawing?
In the first paragraph, it says a third party support provided a letter for the Home Office explaining the size or number of people living in his home and that he could no longer support Ko Brown.
Right. So, but at this point, does it really matter whether he withdraws or not? He's already in the middle of the ocean. Does it really matter?
Okay.
It doesn't matter. You've already committed.
Right.
So before you commit, before you jump into the ocean, you must be sure that you can swim to the end.
Okay.
Whether he knew about it or he didn't know about it, that is the commitment he made to his friend. And the case of SAG and others versus the Secretary of State 2024 is clear. The High Court case is clear that if you commit, you must commit to the end. Cannot change your mind. And so, if he decides not to help Co anymore, what will happen? He has committed. He must continue. If he doesn't continue, what will happen to Co's application or request?
Well, rejected.
Exactly. And the answer is 1.
Well, those of you who chose 1, the Home Office, as per the case of SAG and others versus Secretary of State for the Home Department, this England and Wales High Court case 2984 says that the Home Office will routinely ask for disclosure of third-party support information if they are supporting you with accompanying food or money. They may choose not to be provided. That may mean that there is less compelling case that the applicant is at imminent risk of destitution. That would be the case if there were positive evidence that a third party was unable to provide support or continue providing support. So the answer, as lawyer has indicated, is number 1. Well, that was a very technical and thought-provoking one. So on the back of that, I'm going to ask lawyer to quickly break down what we discussed this afternoon so we can draw the curtains down conveniently.
Thank you very much, viewers, listeners, for your time with us this afternoon. Today, we have looked at financial requirements for different types of UK visas. We started off with visitors' visas. We said that there's no specific requirement. However, there's logical conclusion to be drawn by the caseworker as to whether the person can afford the trip or not without experiencing financial difficulty. And that can assist the caseworker to decide whether this person, the applicant, is likely to return from the UK or not. There's no requirement, but there's common sense requirement, which is even more technical than if there were a requirement. So be careful if you're applying as a visitor and how much money you can show or it will cost you to embark on that project. Now we moved on to student visas. We looked at appendix student guidance for caseworkers. We specifically looked at paragraph ST12, ST12.3, ST12.6, ST12.7. We looked at ST12 to conclude that if you're applying as a student and you are not already in the UK, where you have lived in the UK for 12 months, and you can show that your life continues, or you are not in the UK being sponsored by a government institution, or you are not coming from abroad and you are being sponsored by a government institution or a third party scholarship and so on and so forth, then you have to show that you can maintain yourself. And also, if you are dependent, you can maintain yourself. In that case, the requirement is about 1,529 for 9 months. And we did the calculation and give and take, we came up with about £14,000 for the period of study. And therefore, that money must be available. We then went, and the money must be available in the account for 28 days up to the date of the application. And again, we went to paragraph ST 12.7, and we said that, or discovered that, even though the money has been there for 28 days before the application, and you have met the requirement under paragraph ST 12.6, you have to also show that before the application was made, the money was not withdrawn. And if the money was withdrawn from the account before the decision was made, you have to show that the withdrawal was necessary because you needed the money to pay for the outstanding tuition, or you needed the money to pay for accommodation, or you needed the money to pay for any other relevant cost associated with that application or studies. If not, the application will be refused because you have not met the requirement. We then moved on to skilled worker. Again, we looked at the relevant provisions, specifically paragraph SW 3.2 going, and we discovered that if you're applying as a skilled worker main or skilled worker dependent, if the employer has not already guaranteed maintenance for the main applicant and also the dependents, then the dependent or the main applicant must show that they meet the requirement, especially if the person has not already been in the UK for 12 months or more at the time or date of application. We concluded that from the requirement, you have to show about 1,230, give and take, a month. And that money must be in the account. In this case, we don't have to multiply, it's just that amount. And it has to be in the account for 28 days before the date of application. In this case, if after the date of application you withdraw the money, it doesn't affect you compared to student visas. So that's the requirement here. The next one is Appendix FM applications. If you're a spouse, we said you have to show 29,000. Again, applies to armed forces spouses. We looked at the case, a point where you may be applying as a partner, but your main sponsor is on a benefit. And that benefit is to do with disability, what we call personal independent payment. In this case, you are exempted from the 29,000 financial requirement. So that is a point to note. We also looked at individuals who will be applying as parents. If you're applying as parent under Appendix FM, you do not have to show financial requirement if you are applying under the 10-year route. If you're applying under the 5-year route, they have to show maintenance, adequate maintenance. Adequate maintenance is defined in the case of Voodoo as money enough to survive after you have paid your rent and council tax. And that money should be equivalent to somebody who is on the money received by somebody who is on benefit. For a month, benefit threshold is about 1,800, give and take 1,900. So if your income per month from all sources of income, including benefit, after tax and rent is up to about £2,000, then you are able to sponsor yourself as a dependent, as a parent, or you are able to sponsor your partner if you are applying for your partner on the basis that you are disabled person and you receive personal independent payment. We also looked at EU nationals and family members who are applying for pre-settled or settled status or applying to enter the UK under the Withdrawal Agreement 2020 on the basis that they are applying for family permit as EU nationals. Those people do not have any commitment to make or show because there's no requirement for EU nationals about finance. And so they are exempted from financial requirement altogether. These are the conversations we've had so far. And of course, you know who to go to and where to go to if you need further assistance. Pleasure helping.
Well, who to go to, where to go, you need to go to BWF Solicitors, located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. Call them 0208 493 7340, 0208 493 7340. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Lawyer Charles Osma, thank you so very much for your time and the share of knowledge this afternoon. To BWF Solicitors, thank you so much for the opportunity you give us every weekend on a Saturday to come the way of the community to enhance our knowledge and also empower us. And to you out there, without you, wouldn't have a program. So please accept my sincerest gratitude and appreciation And I believe that you would want to join us again same time next week for another wonderful edition of the Community and the Law. I worked with Shilankra Padmo Dodu and my producer, Professor Ade. My name is Uriku Frimpong. Have a good evening, and let's make a date again, same time next week.